addresses essentially a desire to have us here consider additional paperwork, additional filings. Paperwork is the wrong word, filings in this matter. I'm going to ask that the participants in this matter will argue that in front of the commission. The commission will then rule on the point of order, and then we will turn to the substance of the challenge. Because the respondent in this case, Mr. Michels, did not have the opportunity to file a written response, he will get additional time to respond. So his representative will have 5 minutes to respond to the point of order. Those appearing on behalf of Mr. Bernstein will have 3 minutes to present their point of order. And the point of order is where in our materials? Or is it in our emails?
Yes, it does not appear in the materials. It was information that was provided in writing to the commission for consideration. I'll resend it right now.
I think that would be
just 20 minutes to talk. Wasn't that what it was about? Or is there more to it than that? I thought they just, the point of order was to give them 20 minutes to talk instead of 5. Am I wrong in that?
I think that's what they're here to talk to you about.
That's what they're going to present on, and
Okay.
Administrator Wolf is going to send us those so we can refer to them as they go along. And for those folks who are watching, because of the timing of everything, the points of order were due late last night. Staff did not have an opportunity to review, consider, et cetera, deal with them, and we don't expect them to be able to do that. So it's going to be on the shoulders of those presenting to us and on us as commissioners to consider and decide them. Megan, do you maybe want to tell us what time you sent it last night? Because I know I saw it.
Can't hear you.
I'm working on finding it. Many emails, so I'm having a hard time locating it.
Madam Chair, if I may, there are 2 separate points of order.
That's what I thought. So that's why I wanted to make sure that it was sent to the commissioners, so we could take a quick.
Yeah. So I
Would it be
believe
possible to screen share that?
It was sent by Jim at 9:13 last night.
9:13, yep.
There we are. I see it.
Jim, could you resend just that document, please?
Sure.
Thank you.
Although that may have only been the exhibits to the previously sent point of order. Nope.
That's the point of order.
Yep.
Okay, so you're saying it has an email too, just the points of order, is that right?
Yep. It's how to do
I
it
have
right now.
exhibit 1 point of order, and exhibit 2 is a different font.
Yep.
Is there anything else besides those 2 documents?
And then I think if we scroll far enough,
Yeah, there's a third
exhibit 3.
email. Yeah.
And that is from the other party. So this was a consolidated document of those. Because we had sent the spreadsheet that listed who wishes to speak in what order, who had points of order, and then referenced the exhibits that would be coming. And then we kind of combined all those into this.
Okay, where's exhibit 3?
If you scroll all the way to the bottom of the exhibit document, that would be the email from Attorney Fernholz that references their desire to object to the materials formally.
Okay, so we're going to have
Is that,
okay, so we have to figure out what order we're going to take these in. The first, I mean, the point of order by Mr. Fernholt is that submitting the points of order is untimely. And then we have the two points of order, the substance, of them.
Isn't it possible to address them both at the same time?
You mean all three of them?
No, I mean the substance and the procedural aspects of the points of order. I'm used to circuit court where anything goes, so.
I apologize. I'm not following what you're suggesting.
You're saying that there's an issue about whether we should even consider the points of order, and then a question about the merits of the points of order, about whether they should be allowed more time or allowed to supplement their defense of their complaint, I guess, right? Is that what I understand is going on here?
Well, and then the question is how much time do we want to allow folks to discuss the various points of order before we? This is all new ground. Commissioner Thompson?
Can't we just put everything 10 minutes each side, lay it all out, and then we'll talk about it?
Well, isn't the point of order that they want more than that?
More than what? More than 10 minutes?
That's the second point of order.
Yeah, but how much more than 10 minutes do they need? I mean, this is not the Supreme Court.
Well, isn't there also an issue about being able to supplement? I mean, again, I haven't seen the supplemental submission, and I think Jim may have, but what I understand is there's factual material and argument. Am I correct, Jim? You're muted.
Right, and we haven't seen that, right?
Right, and so I think the question is, do we allow the point of the point of order, as I understand it, is are we going to allow the complainant to supplement their response and give them 20 minutes on the merits? Am I correct on that, Jim?
Correct.
Yeah, but I think that weren't we going to, what Ann was saying is we're going to give each side some time to say why we should accept the point of order before we accept the point of order.
Agreed.
I think we refuse to accept the point of order.
No, I agree. I think it makes sense. I think Ann suggested giving the complainant 5 minutes, I'm sorry, 3 minutes to make their point, and the candidate, the respondent, I think 5 minutes because they hadn't seen it. Is that correct, Ann?
That is, what I would suggest though is before we have them do that, that certainly the commissioners would need to take a few minutes and just read those documents so that folks aren't, I think it would be worthwhile for people to just take a couple minutes and read at least the points of order so that we will have that basis and then the folks can argue. I guess there's 3 arguments. I don't think it's reasonable to have someone have 3 minutes for 3 points of order. So,
Madam Chair,
one at a time.
Madam Chair, I apologize for interrupting. I just want to be clear. The first point of order, the one about filing a reply brief, it is not the case that respondents have not seen that. I shared a courtesy copy of all of those materials, and Mr. Fernholtz and I had an email exchange yesterday. So certainly he should have ample time to respond, but I don't think that I should get less time to speak than he is not any less prepared. And the commission hasn't read the materials. I'd be happy, we can just handle it orally.
Well, I think we still need to know if we're going to accept any points of order or any extra stuff. We need to determine that first before we spend a lot of time listening to whatever the arguments are.
So
I'll make a motion that we do not accept any points of order.
okay.
If
There's a motion,
I
is
may-
there a second for that? Hearing no second, the motion fails.
And let me tell you, I'll make a motion, and this is, and again, I want to apologize. I had a discussion with the chair yesterday, and I had an agreement that with her proposal. And so even though I see the merits of not going down this road any further, I want to abide by my discussions with the chair yesterday. So what I would do is I would move that each party give them 5 minutes to talk about the points of order,
All three at the same time?
all three at the same time.
Okay, is there a second for that motion?
Sure.
Okay,
And the second.
Commissioner Thompson seconds it. Will you accept, well,
May I ask a question, Madam Chair?
sure.
I don't know what the third point of order that was submitted by Mr. Fernholz is.
He's asking to strike your points of order as untimely, I believe.
Okay, I mean, if that's it, that's fine. I was gonna say, it's just hard for me if we're gonna go in order and I'm gonna speak for 5 minutes and he's gonna speak for 5 minutes. I don't know how I'd respond without knowing what it is. But if you represent that that's what it is, then I will fit it in.
Here's literally what it says. At tomorrow's hearing, I will be raising a point of order objection that these materials are untimely, referring to your materials, and thus should not be considered by the commission, period.
So
Mr.
it's, I mean, that's
Fernholz,
just,
is that the sum total of your point of order?
That
I mean,
is correct.
you have words to say about it, but is there any other filing that you made other than that sentence in that email?
No, my only point of order is for the commission to reject the reply material submitted by Attorney Mandel yesterday.
Okay, so let me clarify. Essentially, your point of order is, I disagree with his point of order. Is that right?
Yes, I think there are respectively 2 points of order. Yes.
Okay, we have 2 points of order. Good. This is why we get paid the big bucks here. All right, we have 2 points of order. The first point of order is Mr. Mandel's motion that the commission consider supplemental materials filed in this matter with regards to the challenge. And the second point of order is to allow for moderately extended time for argument instead of 5 minutes to allow for 20 minutes. Do I have that correct, Mr. Mandel?
yes.
Is that your understanding, Mr. Fernholz?
I am learning today for the first time of the request for 20 minutes, but I'm prepared to proceed on that. Yes.
I am assuming you would like 20 minutes?
I actually don't think 20 minutes is needed. I think 10 for each side is sufficient.
Okay. All right. So meanwhile, on the table is a motion for argument on what we have now established is the 2 points of order for a period of, what was it, Mr. Millis, 5 minutes per side?
5, that's what I suggested.
Okay. Is there discussion on that motion? All right.
Motion, yeah.
Hearing
Listen,
none.
okay.
What, I'm sorry, Bob, do you have something to say?
5 minutes each, right? 5 minutes each.
That was the recommended motion on those. Okay. Any other discussion? No, we will call the vote. Commissioner Bostelman,
Aye.
Commissioner Glancy,
Aye.
Commissioner Millis,
Aye.
Commissioner Spindell,
Aye.
Commissioner Thompson.
Aye.
I'm hesitantly voting aye. I think a little more time would have been helpful, but I'll accede to the consensus of the commission. All right, commissioners, have you had an opportunity to read the points of order? And if not, we will have a moment of silence while you do so. Have you had a chance to read those? And if the answer is no, just shake your head and we'll just take 3 minutes of quiet and we'll read them. All right, we're going to take 3 minutes and just everyone can read the PDF that Jim sent of the points of order. We're not reading the substantive stuff right now. when commissioners are ready, they can just look up and then we'll know that we're ready to go, but there's no rush. Okay. Looks like everyone's had an opportunity to review them. Based on our prior motion, Mr. Mandel, you will have 5 minutes to address the commission. Then Mr. Fernholz, you will have 5 minutes to address the commission. Go ahead.
Thank you, Madam Chair, and thank you, commissioners, for hearing these points of order. The first point of order is that we submitted on behalf of Ms. Bernstein yesterday a short reply brief and 2 additional affidavits. I want to be clear that we have more than just a verified complaint and a verified reply in this case. Mr. Michels also served a correcting affidavit. And the response to our verified complaint is not a response that denies any of the facts. It is a response that raises new arguments, both factual and legal. And as the party, the complaining party who has the burden of proof, we should have the opportunity to speak last. That's a fundamental feature of due process in the American judicial system. And due process has been held by Wisconsin courts repeatedly to apply to an administrative hearing like this one. We cite some of those cases in paragraph 6 of the point of order. 2 years ago, Madam Chair, you recognized the most analogous procedure to what one of these ballot access complaints is like is summary judgment in a civil court. That is an apt analogy, and that, along with the burden of proof we bear, militates in favor of our being allowed the final written word in a reply brief. We did serve all of our materials promptly upon the other side so that there would be no unfair surprise. I would also say that nothing in the Commission's rules or regulations militates against this request. Chapter 2 of the Wisconsin Administrative Code, the election piece, provides for briefing here. It does not preclude a reply brief. It does not guarantee one, but I think that's largely because of the tight timeframes. I mean, many of the responses did not come in until last night. On our complaint, that's not the case. The response came in on Tuesday, and we filed our reply materials yesterday morning, giving more than 24 hours for the other side to look at them. Let me move from that one, where in the absence of an express prohibition that doesn't exist, the commission should accept our additional materials, and they should absolutely be part of the record if this matter does proceed to court. But also note that I gave the commission's staff advance warning this was all coming. And on Wednesday, Mr. Witeka assured me that once it came in, it would be all of the materials, not just the point of order, but the submitted materials would be promptly distributed to all commissioners. From the conversation before this point of order, it sounds to me like that might not have happened, and I'm a little bit confused and dismayed. The second point of order was to extend the merits argument here. And let me explain why, because I don't ask this lightly. I know this is a long meeting. I too have been sitting in since the very beginning. But the memo that came from the staff last night says that that Ms. Bernstein as the complainant, that we carried our prima facie burden. And then it says that the submissions by Mr. Michels convinced the staff that the complaint should be denied. It nowhere says which submissions or which argument. We are therefore left in a position where we have to address every single piece of evidence and every single argument. There are 4 affidavits, there are 15 separate exhibits, and there's 19 pages of legal argument. It simply isn't possible to address all of those things in 5 minutes, but because we haven't been given a reply, because even if the reply is accepted, the commissioners won't have had full time to read and consider it. And because the staff memorandum does not give us any guidance on what it is that is driving that recommendation, we need, as a matter of due process and fundamental fairness, to address each and every piece. I will endeavor to do that as quickly and efficiently as possible, but my outline of what I feel is necessary to say to the commission is 5 pages long. With that, I'm happy to take questions, but I'm well under my 5 minutes, and that is my position on the 2 points of order. Thank you for your consideration.
Thank you, Mr. Mandel. Are there questions for Mr. Mandel regarding these points of order that he's just addressed? Okay, we will turn to Mr. Fernholz. Mr. Fernholz, you also have up to 5 minutes. You may proceed.
Thank you, commissioners. I want to start by objecting to the reply material submitted yesterday by Attorney Mandel. I did not receive them in the morning. I need to point out we received them early in the afternoon at 12:40. But ultimately, these need to be rejected because they are not permitted under the commission's rules. Administrative Code EL 2.07 sub 2 sub B provides, and here's the quote: "The response to a challenge to nomination papers shall be filed by the candidate challenged within 3 calendar days of the filing of the challenge and shall be verified. After the deadline for filing a response to a challenge, but not later than the date for certifying candidates to the ballot, the Elections Commission or the local filing officer shall decide the challenge with or without a hearing, period," close quote. Now, because Mr. Mandel elected to file this challenge on a Saturday, our response was due on Tuesday the 7th. Arguably, it wasn't. That issue was discussed earlier. We could have considered those weekends as not counting towards the deadline and potentially filed our own responsive materials yesterday. But we elected to comply with the tight timelines. Now, these rules in the Elections Commission regulations do set tight deadlines for filing a verified complaint and a response to the complaint. And there's nothing that permits a reply by the complainant. And Mr. Mandel looks at this absence of anything on a reply brief and says, well, nothing precludes it from being filed. And it's just as true that nothing precludes me from filing a reply brief this morning that the commission could have considered. But it's not permitted in the rules and it shouldn't be allowed. The commission staff attorney recommendation came shortly after I received this reply. It appears that the staff did not review it. The commissioners have not reviewed it. To allow it now would be prejudicial to my client, Mr. Michels, as it's new information the commission would be considering on the fly today. So with that, I respectfully request that the commission reject all of the reply materials that were filed yesterday. I've already stated my position on the oral argument. I think 10 minutes is sufficient, given that, as Commissioner Thompson said, this is not the Supreme Court, but I'd be happy to answer any questions from the commission.
Okay. Are there questions for either Mr. Fernholz or Mr. Mandel regarding these issues? So I have some questions. Mr. Fernholz, Mr. Mandel indicated that there were affidavits and the like that were filed on behalf of Mr. Michels that could not and were not known to him at the time of the filing of his challenge. Do you agree that that is the case?
Do I agree that Mr. Mandel did not have those materials at the time he filed? Yes, I agree with that because we filed them after he filed the challenge.
So especially things like the apparent timing of posting of the nomination papers and the like, would he have had any way to know that in advance of your filing?
I'm sorry, Commissioner, what fact exactly in the affidavits are you referring to?
Just by way of example, I think one of the affidavits was from Mr. Michels himself about somebody had posted the forms, a staff person had posted the forms inadvertently, putting the wrong one up or something along those lines?
I don't believe Mr. Mandel would have been aware. Well, I should take that back because Mr. Mandel's complaint attached both the nomination forms. If you accessed the second form that was attached to the website, you would have noted that was the form that we attached as Exhibit B. So certainly Mr. Mandel was aware that there were two different forms. I can't say that he knew that one was uploaded to the website and the other were distributed to circulators. But that fact alone, I don't see as permitting him to file significant reply materials.
Well, what I'm trying to figure out is, in most of these cases that we've heard this morning, we're arguing about a mutually understood set of facts. And it seems to me that what Mr. Mandel is contending is that the information provided in your response was not information that he could have known at the time of his filing of his materials. And therefore, under due process, he would like to be able to therefore respond to those, apparently in writing and in a more lengthy argument. And what I'm trying to figure out is whether or not his contention that he would not have been able to know those things at the time of his filing is in fact correct. And it sounds like to a certain extent, he is right that he would not have known that those facts or arguments were going to be presented.
Well, if I may say something in response, that is always going to be the case. We've heard a number of challenges today already dealing with were the addresses incorrect, were the signatures legible. Someone files a complaint, the other party files a response attempting to address certain disparities or questions on the signature pages. Of course, the person who files the complaint is not going to know what the response is going to be. People can say, this is what the actual name is, or that's the correct spelling. So there are always going to be, to some extent, new facts and new information introduced in a response. That's what the response is. So to say that he did not know every piece of information or every argument we were going to raise in our response is true, but that's true in every case. And so I don't see it as permitting an exception to allow him to file a reply here.
Do you agree that the commission has discretion to decide whether or not to accept these materials?
If it's by a majority vote, yes, it would require a 2/3 vote, I believe.
And how do you reconcile sub 2B with sub 4 under 2.07? And the reason I ask is this came up in 2020, as I recall, which is we have the deadlines for responses and the like, which have time limitations. And then we have sub 4, which says the filing officer shall examine any evidence submitted by the parties. So it seems to me that there's some opportunity for the commission to consider what it chooses to consider from the parties.
Well, I would put it back and say if that subsection is read to say that the commission can consider anything at any time, then there really aren't any deadlines. Anyone can file anything because the commission could ignore the deadlines and consider untimely filings. So yes, the commission can consider any evidence on the assumption that it is timely filed and it is permitted.
Madam Chair, may I speak to that?
Sure, go ahead.
Before you do that, what, can you remind me, what site was that?
We're
That
talking about,
was 2.07 EL 2.07 sub 4.
Thank you.
it is, and to be clear, what it says is that the Elections Commission, quote, shall examine any evidence offered by the parties. It is not discretionary. When the parties offer evidence, it is supposed to be considered. And we did so here in a way that is not precluded by the rules, that gave fair notice to all parties. And I would just briefly like to say that I disagree with Mr. Fernholz, that they could have held their response until Thursday and precluded something like this as a practical matter. EL 2.07 sub 2 paragraph B says that a response is due 3 days after the filing of the complaint. And the timing rule in Wisconsin statutes 990, on which the commission staff relies in saying that complaints weren't due until Monday instead of Saturday, is about the day of a deadline. It's not about the day of something starting. So there's no doubt that Tuesday was 3 calendar days after Saturday, and there's no doubt that the complaint was timely filed on Saturday, both in person and by email.
Okay. All right. Are there any other questions for Mr. Mandel or Mr. Fernholz on these points of order? So I am personally, I'm troubled at the idea of sort of the commission having willful blindness for information relevant to our decision when properly filed and submitted. And I am uncomfortable with that in part based on how we've considered things in the past and how we do try to get to the bottom of some of these issues, like looking up Mr. Sean, whatever his name was, and finding out that that person apparently does exist with that spelling as set forth by Commissioner Michels in Brown County, which sort of ended that analysis. So we consider things outside of physical filings on our own instigation and the like. And I'm concerned at the idea that we are not going to hear relevant, what I can only assume is relevant argument, because if it's irrelevant, we're going to disregard it anyway and not consider it in any form. But it seems to me that our record is better if we consider information than it is if we don't. To Mr. Mandel's point, it is my position that if the commission does allow for us to consider those materials, we will again just take a period of quiet for 15 minutes. Commissioners will be allowed to read and consider. It's the nature of the beast on these things that we have these time periods where sometimes that's what we have to do.
I have a question, two questions of staff. So first one is to Jim. Mr. Mandel made a representation about some comments that you made about what would happen with the late submission. Can you respond to that? I don't remember exactly what his words were. It's been like 10 minutes ago. So I think the thought was that you said that they would be distributed to the commission?
My recall was that these would need to be conveyed to the commission, or it would need to be determined by the commission whether they were timely filed. And then obviously my question, as those thoughts progress, is whether or not that would, if sent before the commission weighed in on this, improperly color your decision. And so when we had a dry run through yesterday, not on content and not with a quorum, but rather on procedure, I believe both you and the chair felt that the argument that the commission should not see that until they've had the opportunity to look at the matter itself and then collectively weigh in on whether they should see it was more appropriate. But the staff could potentially look at that to have an informed discussion as part of that process.
The second question I have has to do with the record on review. And I'm familiar with chapter 227. Generally, I've lived probably good 20 years of my life or more dealing with that chapter about what's on review. And I was looking at, and this is in reaction to a comment from Attorney Mandel about the record on review and whether we accept the filing or not. I'm looking at 227-55 sub 1, which is a general statute that talks about the record on review, and it includes all pleadings, notices, testimony, exhibits, findings, etc., that are part of the record on review. And I spent, some of you know, I spent close to 10 years as a member of the Tax Appeals Commission. And when matters were appealed from the commission, the Tax Appeals Commission, everything in the record was sent to the circuit court. Exhibits that we refused to receive as evidence were submitted. Motions and affidavits that were stricken were submitted because those are all things that the court on review can decide was appropriate. So my guess is whatever Mr. Mandel has submitted to staff would be part of the record if there is an appeal, would go to circuit court. Am I correct on that?
You are, and EL2 also explicitly pulls in both chapter 505 and 506 as the foundation for this. Now, I would also argue that this is an administrative code-based and created process that does have some explicit requirements. I mean, certainly it's not to discount what Attorney Mandel said, because I have made arguments, but not related to procedure, if you will, that the lack of something in statute could potentially if we feel it's ethical and lawful, allow someone to go either way. I've made those arguments, but I think the procedure here is strict. I think it's an administrative process, so that I think the analogy to a court proceeding is not appropriate. I think the timing of this is quick for a reason, because there's also ballot printing and finalization implications, and they do have the appellate right within the circuit court that is tied into this process through Chapter 5. So I think all of that kind of lends itself to, a belief that, well, do you want my opinion, I guess is the question on the overarching topic. But more than that, the only other thing I would add before you answer that question is Mr. Mendel, when he was saying there is a deadline in 3 calendar days, did not use the shall that's in that line that is also in the other line he quoted. And I think those two sections of 2B and 4 are intrinsically kind of tied together, with one being a shall file within 3 calendar days and one being a shall consider.
Madam Chair, I guess I'd like to make, well, if Bob speaks, but I'd like to make a motion on this at the appropriate time.
All right.
That's, you may.
Well, I'll to get for purposes of discussion, actually more than purposes of discussion, I would move that we would deny the point of order with respect to the request to supplement with the written filing.
Okay.
So-
Only as to the written filing.
Yeah, we'll talk about the 10 minutes later. Let's do them one at a time. That's my suggestion.
Madam Chair, may I ask 2 questions quickly?
No, because there's a motion pending, so you may not.
So,
you gotta wait
and on
to
the motion,
I'm sorry?
and on the motion, if I could.
Well, no, you got to get a second.
I thought,
We have the motion on the floor right now.
I
Yeah,
have
I
a
think
motion
Bob-
from you. Did someone second it?
I did, I seconded.
Okay, Commissioner Spindell says he seconded it.
okay, so.
Hold on.
Sure.
Mr. Mandel, I'm going to come back to you. I'm going to unless there's something factual that is important that we know before we discuss this motion.
There are, if I may, Madam Chair, I'll be very quick.
Commissioner Millis, is that okay?
Fine.
Okay.
First of all, I appreciate Commissioner Millis's comments about 227-57, and I couldn't agree more, except that 227.03 subdivision 6 excludes judicial proceedings to review an order of the Elections Commission under section 5.06. So this would not be a 227 appeal. This would be a 5.06 sub 6 appeal. And so regardless of whether the commission accepts for its own consideration today the materials, I would ask the commission to please determine that the materials would properly be part of whatever record the commission would forward if this were to go to court. Secondly, I just have a question. In the past, when we've had these points of order have not been handled by motion, but have instead been ruled upon by the chair, subject to an overrule from the commission. But this seems to be being handled differently, and I just wanted to ask about that.
It is being handled differently.
So
It's
Question.
Or we should have some on the motion.
I have a question, the discussion, this is on the motion. I have a question to the staff. I have a recommendation not to sustain the challenge to Mr. Michels' ballot access. Would the material and reply impact in any way the staff's recommendation in that regard?
No, I do not believe so. And certainly, Brandon and I as a legal team, with the importance and the overlap between the final complaint that he'll be speaking to and this one, coordinated our efforts quite a bit. And I don't want to speak for Brandon, but I think we would both be of the same mind that I don't know if Brandon, if you read that additional document, but I do not believe that it would change things. I will say, to answer the earlier question, that I do wholeheartedly agree with Attorney Mandel that this would be a 5.06 appeal into the circuit court. And I can confirm to the commission that our statement on that still remains true, that We have an order under that provision of statute that requires us to compile the complete administrative record and submit that to the court, I believe, within 30 days. And I would absolutely consider anything that was ruled upon and perhaps not considered as something that would become part of that record, so that any proper appeal could be made with the documents in hand.
So I have a question to Commissioner Michels. Given that it doesn't sound like the staff's recommendation in any way is impacted by consideration of the reply, it would seem to me that would you reconsider withdrawing your motion? That way everything's sitting here on appeal if there is an appeal. And I say if there is an appeal.
I guess I probably not. And here's my thinking. I think what Jim has just said is that regardless of how we rule on this motion, the materials filed by Attorney Mandel will be part of the record. And certainly if the vote doesn't go the way Attorney Mandel wants, he can certainly make the argument in circuit court that we should have considered that. In fact, regardless of what Jim and Brandon feel, perhaps convince the court that it should make a difference into the outcome. My feeling on this is, and I guess I haven't talked to Jim about his position, but I think we're probably in accord. We're an administrative body, we're not a circuit court. And I guess I would respectfully disagree with the suggestion that this is like summary judgment. It's an administrative proceeding, and I have procedural concerns and practical concerns. One is if we allow this sort of appeal, it's going to encourage gamesmanship. And so if I'm representing a candidate, I'm going to file my response at the very last minute, because if I file it earlier, that opens up the possibility, it makes it easier for a response. And I think it's not a good way to run the railroad. It's going to create more hassles for staff. You heard at the beginning of the meeting, I think that we should have more time for this. If we could change the statutes and have more time for this and have a more deliberative process, I guess I wouldn't be opposed to that. Generally speaking, even in summary judgment, when I served on the Tax Appeals Commission, and even in circuit court, often the reply in the summary judgment proceeding often does not, the court or the administrative agency will not allow new factual evidence. In fact, my standard order was that the reply was only a reply brief, and you had to ask permission to submit additional factual materials, and you had to show that there was a good reason for that. Perhaps a new issue had been raised or something like that. But that's in circuit court, and that's a different proceeding. And I think this is an administrative procedure. Again, I think what counsel for the commission has said, that what Mr. Mandel has filed will be part of a record if the case doesn't go his way. I think we should proceed. I think it's just going to set a bad precedent. And this is an important issue, but all the cases in front of us are important, whether you're an assembly candidate, Senate candidate, or candidate for governor or secretary of state. And so for that reason, I still stand by it. I'd like to have a vote on the motion.
Madam Chair.
I'd like to make a comment, we're discussing the motion.
Hold on. Commissioner Thompson, then Commissioner Spindell can talk on the motion.
Sure. Since we're here with the motion, it's not being withdrawn. It's important, I think. I don't think this raises any due process implications, Attorney Mandel. Reply briefs are, I think Mr. Miller said it, sometimes not required, certainly never ever deemed that if you don't reply, there's a due process violation. And the reason I think a lot of courts say that, I've been in court many times and nobody gets replies. And from the court's point of view is that if you've got something to say, you better put it in your brief in chief, because if you don't, it's not very important. And so I think from a procedural point going forward, I don't think that as an administrative body, we have to adopt a position that reply briefs are a matter of due process and required. I just agree with Mr. Michels in that regard, that this would be a discretionary vote. And now, I think it would be a good thing to put it all there and discuss the whole issue. And that's, because I don't think it is outcome determinative. And I think the issues are teed up anyway. But I think it's important for the public to know that by us, if we vote not to accept this reply, that there is any implication that due process is being violated. I just think that's wrong. Reply briefs are generally at the court's discretion. Some places they're part of the rules, some places they're not. But and this notion that as the movement that you have the right to the last word, that's not always true. It's not true in court. It's not true in every civil case, and it's certainly not true, and it hasn't been part of this agency's discussion since 2016 when I was the chair. I mean, sometimes we've had replies, sometimes we haven't. We've never said you have it as a matter of right. So I just wanted to make that comment.
Madam Chair, may I respond briefly? He addressed me directly.
I want to talk, it's been a while since I had a chance.
Hold on, Bob.
If we're giving an attorney to talk,
Hold on, Bob.
both sides.
Bob, just hold on.
Okay.
I actually agree with you. Mr. Mandel, you can address after Commissioner Spindell speaks.
Thank you.
Go ahead, Bob.
Also, after in particular, one of the attorneys talks, I think it's only fair to give the other attorney a chance to talk there. I think we all need to remember that we're a commission. We're not a court. We're commissioners. We're not judges. This particular challenge and whatever went on until 3 o'clock, 4 o'clock in the morning. And if we continue to take additional information, how much longer is this going to take? There, as you've all pointed out, there's a deadline in terms of deadlines when stuff has to be filed. Everybody is not going to get the last word on everything. Otherwise, we'd be going through the election without anybody winning any of these particular situations. Also, one of the reasons why this extended so far, correct me if I'm wrong, Megan, but we had a situation where an incumbent did not indicate that he or she was going to not run again, which extended several days for a particular challenge to take place and come through. So it's not that we extended everything to the end of the week. It was one particular area there. So we just can't continue on this. And I think everybody has had a chance to say what they needed to say. Obviously, if this is appealed, it goes to circuit court. The circuit court gets everything in the bundle. So I think we need to favor the motion that we do not allow to have this particular point of order or at this particular late date.
Okay. Mr. Mandel, I did say that you could respond to Commissioner Thompson. And then I will allow Mr. Fernholz if he has something to add with regards to that after you speak. So please go ahead.
Thank you, Madam Chair. I would just note that Commissioner Thompson is correct that there are certain circumstances in which courts don't allow reply briefs. But we're in a weird posture here because the commission accepts complaints, which are allegations of fact, and it is also hearing arguments of law. It is deciding everything all at once, whereas courts usually accept pleadings, complaints and responses, and then motions that are on points of law. Essentially what happened here is that we filed a complaint that made certain factual allegations. Mr. Michels did not just deny those allegations. He raised his own affirmative facts, essentially affirmative defenses, and we should have the chance to respond to that. If this were a court, we would have the chance to file an answer that would not amend our complaint, but would respond to those new factual allegations, I believe the commission should give us that opportunity. I recognize this is not a court, but I would point everyone toward the clear and established longstanding case law in Wisconsin that says administrative agencies acting in an adjudicative capacity, which is what's happening here, are bound by due process. Thank you.
Okay. Mr. Fernholz, do you have anything to add on that topic?
Just very briefly, this is not circuit court. Our response to the complaint was proper. There's no allegation that it was deficient. Rules don't allow for a reply brief, and if the commission is going to allow it, it is going to encourage a flurry of reply filings. We complied with the deadlines. We believe that those are enforceable, and the commission should not allow any additional materials outside of its rules. Thank you.
Commissioner Bostelman and then Glancy.
I just want to say that this is the 11th hearing that we've had. So we have not had any additional evidence being brought in to anything in the past. There's deadlines that we live by of complaints and rebuttals, and we've passed those deadlines. So I think by accepting anything today is setting a precedent that it doesn't matter. You just come to the meeting and you can just file any information you want. And I don't think that's appropriate at this time. I think I understand them coming and making an argument, but I don't understand that we would accept another brief, so to speak. And, you know, I've listened to attorneys for the last 15 minutes. And I'm not an attorney, so I'm probably not using the right terminology, but it just seems to me that the deadlines have already been met and additional information, this is not the time for us to be receiving additional information. We've listened to 10 people already, and what they've talked about is what they have already filed. And this is bringing in new additional information. And I just don't think that's appropriate. And I agree with Commissioner Millis's motion.
Commissioner Clancy.
I just have a question. I'm also not an attorney. So my question is, if we do not accept this new document, does that mean that Mr. Mandel cannot address those issues in his oral statement? Or can he still, respond to what was filed by Mr. Fernholz? He
can respond.
Thank you.
He can respond in his oral arguments. I continue to be challenged by this because I don't like the idea of us not having materials for consideration when they are available to us. And there will be times when we need to do that and times when we can decide not to do that. And I feel like this is one of the times where it would be helpful to the commission to have that. And I don't think it's a big, if anything, I think it would actually help the commission to have in writing what we're going to hear orally. I think it's always best to have it in two forms whenever possible. It helps us coalesce around arguments and understandings. So that's sort of my view on this, that I think we should do the best job we can. And when materials are available to us that are germane, I think we should accept them and consider them when we have the opportunity to do so. We won't always have the opportunity to do so, and I get that. And I get that it's 2 o'clock, but I don't think we're going to go till midnight on this. I think we'll be able to make our way through on it. But I do think that we should consider when things are properly before us. And this is one of those times. So that's my take on it. Jim, do you have your hand up? You're muted.
Muted.
Sorry, yes, if I may, Madam Chair, just a couple of things that I think I would probably be finishing with. And one of them is to specifically piggyback onto what Commissioner Bostelman had talked about. And part of that is I think the commission needs to know before they would make any decision that there is also a matter of equity, because other people had looked to confirm that there was not such a process. We pointed them to admin code and told them no. And so that in and of itself is problematic. And then I think, we have to also look at timing. if there is a aggrieved party and if they wish to appeal, then, we have seen very important election related matters dismissed, say the Green Party case, that because of timing simply can't be heard. And I think that is part of why we have these 3 calendar day considerations as well. It's not just getting ballots to print and subsequent pieces of the election calendar. It's also to give an aggrieved party the potential to file probably what becomes an immediate action, probably seeking an emergency hearing and moving forward in that process as well, so that isn't dismissed because we are already too far along in the process for them to have what I feel is the logical next step. Why we limit those filings, because there is an appeals process. They have an avenue to move forward. So I don't think there's a matter of lack of equity on the other side of that coin.
Good point.
Is there further discussion on the motion? All right, hearing none. The motion is to deny the first point of order as to receipt of those supplemental materials. I'll call the vote. Commissioner Bostelman,
Aye.
Commissioner Glancy,
Aye.
Commissioner Michels,
Aye.
Commissioner Thompson.
Aye.
Chair votes no. The motion carries.
You didn't ask for me.
Oh, Commissioner Spindell, sorry, I skipped right over you.
The first time you ever, I am for the motion. Aye.
Okay, sorry. The motion carries 5-1. As to the second point of order, the amount of time allotted to the speakers is within the discretion of the chair. And as such, I will agree with the point of order and allow each party 20 minutes to present their arguments. If the commission disagrees with my ruling on that, it being within the purview of the chair, this commission can take a vote to overrule that, but my suggestion is we allow the parties to get going, give them each 20 minutes, and we will be able to move on to discussion of this promptly.
Not excited about the point of order, but I prefer, we'll spend more time debating it. But I'm sorry, I didn't mean to cut you off, Bob.
Oh, I make a motion to overrule the chair on this and that the point of order be dropped at this point.
It's going to spend more time on this than anything else. Well, in any event, is there a second to Bob's motion? Hearing none, the motion fails.
I'll second it. I'll second. Let's just vote on it.
All right, is there discussion on that topic? Hearing none, I'll call the vote. Commissioner Bostelman,
Aye.
Commissioner Glancy,
No.
Commissioner Michels,
Aye.
Commissioner Spindell,
All right.
Commissioner Thompson.
No.
Chair votes no, motion fails 3-3. We are going to begin the part of the argument. Mr. Mandel will go first. I'm going to ask that Ms. Hoggy please give him 20 minutes on the clock. Mr. Fernholz will also be given 20 minutes on the clock. Please proceed.
Thank you, Madam Chair. Thank you, Commission. The staff recommendation here is wrong, and the Commission should reject it. The error in the staff memo is fundamental. It first arises in the first paragraph of the memo, where the staff summarizes the complaint. I'm on page 2023 of the materials. That is page 1454 on the PDF. It says, I'm looking at the second sentence, just over 91% of the submitted signatures are alleged to have been submitted on the challenged nomination papers that included the candidate's full address for voting purposes, not mailing purposes. This is false. The complaint does not allege that the challenged nomination papers include the candidate's full address. In fact, the complaint alleges exactly the opposite, and that is the point of this complaint. If you look at paragraph 14 of the complaint, that's on page 1278 of the commission materials or 709 of the PDF, paragraph 23 on page 1280 of the materials, 711 of the PDF, it specifically says that the deficiency here is that the nomination papers include a street address and then say in the village of Shaniqua. They do not say Wisconsin. They do not have a zip code. That is not deliverable mail. It may have been in the days of the Pony Express, that you could say, I'm sending something to my friend at this street address in this village, and it would get there. But in the 21st century post office, that doesn't work. The staff memo appears, as I said earlier, it's really difficult to tell because the staff memo doesn't specify exactly what it finds persuasive after saying that we did meet our burden of proof. But the staff memo appears to rely primarily on two things, and so I'll start there. The first is the idea of a commission precedent from 2018 involving two circuit court judges. That precedent is not sufficient for two reasons. First, the precedent is not squarely on point. The two judges made the mistake of listing their full addresses for voting purposes, but not listing that they live in a separate municipality for mailing purposes. There is nothing in the materials that would suggest that either of those judges left off the state and the zip code from their nomination forms. In other words, the point of that precedent is that if you mailed something, if a voter mailed something to the address on the nomination papers, it would be delivered. But that is not the case here for the reason I mentioned before. You can't just mail something to in the village of Shaniqua. We addressed this in our reply, which the commission has not accepted, but you said I am allowed to talk about it. And there is specific United States Postal Service material, online, published material that says a piece of mail must have a municipality and a state. A zip code is something they like, and it makes the mail go faster. The materials that Mr. Michels submitted all talk about a zip code being optional. That is true. Mail without a zip code will be delivered, but more slowly. That is a different issue, however, than what we have here, which is an address that is missing both a state and a zip code. So the precedent is not on point, and it should not be applied for that reason. But even if it were, the precedent is wrong. The statute is clear. Each candidate shall include his or her mailing address on the candidate's nomination papers, end quote. It is difficult to imagine that the legislature could have been clearer. And I would like to quote to the commission, although I know many of you are familiar, just last year, the Wisconsin Supreme Court said the following in reviewing actions of this commission, quote, simply because an agency took action in the past does not mean its actions were legal. It is the statutory text, not agency practice, that determines what the law requires an agency to do. That was the Zignego case at 2021 WI 32, paragraph 32. So even if the precedent of the 2018 circuit judges were on point, and it is not, the commission shouldn't follow it. And yet the staff specifically says that the commission should follow it. In fact, the staff memo says that, quote, the commission, quote, has traditionally adhered to a standard of maintaining precedent. That's on page 2026 of the commission materials, page 1457 of the PDF. That is completely inconsistent with Zignego. It is not a proper basis for this commission to deny the complaint. The second thing here is factual, and I am going to attempt to get through all of the exhibits, but there is only one piece of material that was submitted by respondent Michels that the staff memo cites. And it's a very interesting choice. On page 3 of the staff memo, which is page 2025 of the commission materials, which is page 1456 of the PDF, there is a citation near the bottom of the page to Miller Affidavit paragraph 3. Miller Affidavit paragraph 3, for what it's worth, is on page 1892 of the materials, which is page 1323 of the PDF. And what paragraph 3 of the Miller Affidavit says is, quote, on June 6, 2022, I contacted the United States Post Office located in Heartland, Wisconsin, which confirmed that it delivers mail to addresses in Shaniqua, end quote. First of all, this is not admissible evidence. It is hearsay. To repeat what someone else told you when they are not named, identified, or made available in any way for further discussion is not evidence. In any court or any body, in any common law jurisdiction, including the United States of America, Number two, consider what is left out of this sentence. I doubt that the United States Post Office located in Heartland, Wisconsin, confirmed that it will deliver anything that is addressed to someone in Shaniqua. I imagine that it should have the qualifier if the address contains proper information allowing it to be delivered. But here, that is not the case. The address does not have that proper information. And I would point the commission to the United States Postal Service's mailing standards for domestic mail manual, section 6.02.1.3, which was updated on April 4th of 2022. And it says that all mail, quote, must bear a delivery address that contains at least the following elements. There's then a list of 6 elements. Item C is street and number. Item D is city and state or state abbreviation. The issue here is that Respondent Michels, the vast majority of his nomination papers do not include a municipality and a state. They include purely a municipality. Mail is not deliverable to in the village of Shaniqua. I'm going to attempt to use my remaining time to address quickly the other evidence that Mr. Michels submitted and why it's insufficient. He provided vague self-serving testimony to the extent that, quote, I recall that mail addressed to my attention at 6831 State Road 83, Village of Shaniqua, has been delivered to me in the past, end quote. That's paragraph 15 of his affidavit on page 2019 of the materials, 1450 of the PDF. This, like the Miller affidavit, is not clear and responsive. It fails to assert that any alleged prior mail, of which we have no details, lacked both a state and a zip code, as would be true here. Miller affidavit paragraph 2 says that the United States Postal Service Customer Care Center told her, quote, that when 2 cities share a zip code, mail addressed to either city will be delivered, end quote. Again, irrelevant and not contested because it doesn't state that the mail would be delivered in the absence of both a state and a zip code. Miller Affidavit 1, USPS zip code, the basics at page 1895 or 1326 of the PDF says, and we all agree, quote, not having a zip code on your mail causes unnecessary delays. It also says on page 5, which is 1900 of the materials, that where the zip code doesn't match the city and state, the mail will be sent to the post office for the zip code. And if that fails, it will be forwarded to the post office indicated by the city and state. In other words, without a city and state, your mail will not get anywhere. We submitted an affidavit to that extent, which contradicts, is much more specific, and contradicts exactly what is stated or implied by the Miller affidavit and materials, and contradicts, contrary to Mr. Witeka's representation. It directly contradicts the staff conclusion, because the staff says on page 3 of the memo that its call to the post office confirmed, quote, I'm in the bottom paragraph on page 3, confirmed there is an overlap in zip codes and that mail addressed to either city is interchangeable. Here by either city, we're talking about the village of Shaniqua or the city of Heartland. But that's not the case if there is no state. There has to be at least a municipality and a state. Mail addressed purely to the village of Shaniqua, just like mail addressed purely to the city of Heartland, will not reach its destination. Miller Exhibit 2 on page 1902 of the materials. Again, not having a zip code on your mail causes unnecessary delays. Agreed. Miller Exhibit 3, which purports to show that if given the address 6831 State Road 83, Village of Shaniqua, WI, Google, the USPS website will then give you Heartland, Wisconsin, and a zip code. The problem is the absence. They're adding WI, which is not on the nomination papers. And I know they say he's running for governor of Wisconsin, so where else could he possibly live? While these papers were being circulated, there was a public debate, including extensive news coverage, alleging that Mr. Michels is actually a resident of either Connecticut or New York, both places where he owns homes, one place where his children, minor children, live and are going to school. This is a real question. And the nomination forms are deficient. They don't meet the strictures Quite simple, straightforward requirements of 8.15, subsection 5, paragraph B. The remaining Miller affidavits are basically just partial Google website searches that, again, are irrelevant and substantially incomplete. They provide just a couple of the results for these Google searches. And then we turn to the Fernholz exhibits. Exhibit A is a copy of the complaint to circuit court appealing from this court's decision related to the nomination papers of Jim Sullivan and Brian Kennedy. It's completely irrelevant. We know that because it's never cited in their materials. Fernholz Exhibit B is the transcript of the temporary injunction in that same case. And this actually, like most of the substantive materials that Mr. Fernholz provides as exhibits to his affidavit, cuts against Mr. Michels. Immediately before the language that they quote, and they quote, I'm looking at page 1958 of the materials. Immediately before the language that Mr. Fernholz likes to quote, the court said, quote, "The court is obligated to reading, where possible, the statute to give reasonable effect to every word in order to avoid surplusage. I know the legislature put the words in for a reason, and the statute can't be read to take out that particular language," end quote. He was talking about Wisconsin Statute 8.04, not about 8.15, but the position is the same. Just like this commission and the court kept Mr. Sullivan and Mr. Kennedy off the ballot, they should do so here because a statute is plain and clear and the campaign did not follow it. Fernholz Exhibit C, page 1981 of the materials, is a February 2020 memo from Ms. Wolf and Mr. Haas to this commission proposing a clearer policy on legal standards for nomination paper review. It is helpful to us because on page 1981 of the materials, it says, quote, it undercuts Mr. Michels' material because it does not address, quote, errors in the information on the page related to a candidate. That's what we have here, errors in the information on the page related to a candidate. And on the substance, it expressly recommends a policy that was adopted by this commission, as documented in Fernholz Exhibit D, confirming that, quote, requirements related to filing nomination papers are mandatory. That's on page 1981 of the materials, such that, quote, the will of the electors language in Wisconsin Statute 5.01 does not apply to the review of nomination papers and election petitions, end quote. It's on page 1984 of the materials. Fernholz Exhibit D is the meeting minutes showing that that policy was adopted as approved. Fernholz Exhibit E at page 1993 of the materials is a January 2018 memo from Mr. Haas and Diane Lowe to this commission about ballot access for the 2018 spring election. It addresses the two judicial candidates who I mentioned earlier. In neither case is there any indication that their nomination papers failed to match their declaration of candidacy, which is true here, see Exhibit A to our complaint, nor is there any indication that the nomination papers contained only a partial voting address that was missing both the state and the zip code. None of this, of course, can be confirmed. We reached out to the Elections Commission staff early this week to ask about this, and these nomination papers and other materials have not been retained. The commission has a 20-month retention policy, Mr. Witeka tells me. Fernholz Exhibit F is an excerpt from the candidate tracking by office for the 2018 spring election, which is the same as what's addressed above. Fernholz Exhibit G is the meeting minutes of the meeting of this commission on January 9th, 2018, when it voted to approve the nomination papers of those two judicial candidates. I would point out, by the way, that those two judicial candidates also had the benefit of a presumption of validity that does not apply here because they were not challenged. Finally, Fernholz Exhibit H is the Elections Commission's guidance on nomination paper challenges from January of 2018. Mr. Michels cites this for its statement that it is this commission's, quote, established policy in reviewing nomination papers to find substantial compliance by presuming the validity of the information listed unless evidence to the contrary is presented. We have presented such evidence to the contrary. That's on page 2009 of the materials. We have presented such evidence to the contrary. The staff memo recognizes that and says we've carried our prima facie burden. Moreover, the guide assumes that a proper mailing address is provided, says there's a presumption the voting address is the same, but Michels is trying to run things in the opposite direction. He did not file a complete proper voting address, and he nonetheless wants it to count as if he met the statutory command to file a mailing address. It doesn't work that way. It also, this same document makes clear that, quote, none of the information in the header of the nomination paper that includes the candidate's address, quote, may be altered, amended, corrected, or added after circulation of the nominating papers. It's on page 2008 of the commission materials. This is fatal to Mr. Michels' submission of a purported correcting affidavit. And the guide makes clear that when the candidate's basic address information in the header of a nomination paper is blank, or it follows incomplete, the paper has been stricken when challenged because the Elections Commission, quote, has found that papers must contain minimum information about the candidate for the paper to substantially comply with the law, end quote. It's on page 2009 of the materials. The McNulty affidavit submitted is of no help to Mr. Michels. That's at page 2015. It says that mail addressed to Respondent Michels at the campaign's P.O. box may reach him, quote, if deemed both safe and necessary, end quote. That's in paragraph 4. In other words, there is no guarantee that mail sent there will arrive to him. And it is really irrelevant because that is not, as the statute requires, Mr. Michels' mailing address. That is the mailing address of the campaign, which is a corporation, separate legal entity and person. Testimony that Mr. Michels and his campaign never intended to mislead anyone on page 2019 is irrelevant. Testimony that Mr. Michels did not know about the deficient nomination papers until after they were submitted to the WEC, also on page 2019, equally irrelevant. It also, I would point out, does not say that he didn't know before the complaint or before the supplementation deadline, but he did submit these papers to the Elections Commission and he made no effort to submit supplemental signatures. This is potentially in tension with a voicemail left for the Elections Commission on May 26th by an individual named Mary McNulty, purporting to act on behalf of the Michels campaign and saying that she had some questions for Mr. Vetterkind about nomination papers for the campaign. We don't know anymore. That voicemail was provided to us late yesterday afternoon in response to an open records request. And testimony that the circulators, rather than Mr. Michels or his campaign, are responsible for errors in the deficient nomination papers. That's in paragraph 12 of the Michels affidavit at page 2019, is irrelevant and it is contrary to law. Administrative Code EL 2.05 subdivision 1 says quite clearly that each candidate bears, quote, the responsibility to assure that his nomination papers are prepared, circulated, signed, and filed in compliance with statutory and other legal requirements. There is simply no basis for upholding what is here. The Elections Commission called to a post office that got information that is incorrect, untested, unverifiable, that we got late yesterday afternoon, and that incorporates material from another memo that we didn't get until almost 10:30 p.m. last night, is not a proper basis. It defies common sense and statutory text to say that an address that is merely in the village of Shaniqua without a state or a zip code is a proper mailing address. This is not a directory statute. I would point you to the Village of Elm Grove case, which is quite clear that a directory statute only when necessary to enforce the clear intent of the legislature. There are no constitutional issues here. I'm happy to answer questions.
Excuse me, the 20-minute time limit is up.
But the constitutional cases cited are directly contrary, cited by Mr. Michels are directly contrary to his position. Thank you to the commission. I'm happy to answer any questions when the time comes.
I think for our purposes, I'm going to suggest that we have both parties present. And then, actually, yeah, I think we'll have both parties present and then allow for, I don't know what that was. And then we can have questions and allow both to respond. Mr. Fernholz, you will have 20 minutes to respond.
Thank you. First point that I want to address is that Mr. Michels' nomination papers fully comply with the statute, and that's Wisconsin Statute 815 sub 5 sub B. Now, Ms. Bernstein says that Michels' nomination paper is inaccurate for failing to include a mailing address. And it's important to remember that she has the burden to establish any insufficiency by clear and convincing evidence. That's Wisconsin Administrative Code EL 2.07 sub 3A and sub 4. So turn to the statute at play again, section 815 sub 5 sub B. It says that each candidate shall include a quote mailing address. Well, that term is not defined. And the case law from the Wisconsin Supreme Court going back decades says that when you're confronting an undefined term, courts can look to dictionaries for guidance as to the plain and ordinary meaning. Merriam-Webster's has a definition of mailing address as follows, quote, an address to which mail can be sent, close quote, as well as, quote, the address at which a person or business receives letters or packages, which can be different from the place where they work or live, close quote. Mail can be sent to the address at 6831 State Road in the village of Shaniqua. And Mr. Mandel acknowledges this point that the zip code is not essential for mail to arrive. Attorney Miller's affidavit explains this in great detail. The United States Postal Service recognizes 6831 State Road 83 in the village of Shaniqua as 6831 State Road 83, Heartland, Wisconsin. That is at pages 1905 and 1907, exhibits 3 and 4 of Ms. Miller's affidavit. The United States Postal Service has confirmed that mail addressed to either municipality with a shared zip code would be delivered. And as noted in Mr. Michels' affidavit at page 2018 in paragraph 15, he has received mail when it's been addressed to 6831 State Road 83 Shaniqua as opposed to the Heartland address. Now, even if an address does not contain a state or a zip code, that does not undo its validity as a mailing address. Let's start with the zip code. The United States Post Office website indicates that mail missing a zip code is not undeliverable, but as Mr. Mandel noted, is merely delayed because the post office looks up the zip code. Addressing the state, although the word Wisconsin is true, does not appear immediately following Shaniqua, Wisconsin is clearly the state for this address. The village of Shaniqua exists only in Wisconsin. Mr. Michels is running for the office of governor of Wisconsin. I understand attorneys have to make arguments for their clients, but to say that the people who signed these nomination papers believe that Mr. Michels' address was somewhere other than the state of Wisconsin is not credible. Both iterations of the campaign's nomination papers also include a return address of a P.O. box in Milwaukee. And this constitutes a mailing address because it's an address to which mail can be sent, as well as the address at which a person or business receives letters or packages, which can be different from the place where they live or work. That was the dictionary definition I quoted earlier. So if mail is sent to Tim Michels, to his attention at the P.O. box, a campaign employee opens it, screens it, and if warranted, then gives it to Mr. Michels. The statute 815 sub 5 sub B does not mean to say that the mailing address must be a residential address. So in conclusion on this first point, the nomination form challenged by Ms. Bernstein contains at least one mailing address in compliance with section 815 sub 5 sub B. The next point, though, is even if the nomination papers contained an error as determined by the commission, Wisconsin Supreme Court precedent and this commission's own regulations and guidance mandate that Mr. Michels be permitted access to the ballot. Start again with the statute. 815 sub 5 sub B is directory, not mandatory. In the election context, courts must construe provisions giving directions as to, quote, mode and manner, close quote, as directory, quote, unless a non-compliance with their terms is expressly declared as fatal or will change or render doubtful the result, close quote. That's the Wisconsin Supreme Court speaking in the Sommerfeld case. In other words, if non-compliance with an election statute is not coupled with invalidity, then the statute is directory, not mandatory. An act done in violation of a mandatory provision is void, whereas an act done in violation of a directory provision while improper is valid. Section 815 sub 5 sub B does not prescribe any consequence for noncompliance. Now, if the legislature wanted to make 815 mandatory, it would have done so. In fact, there are other subsections within 815 that are mandatory. For example, 815 sub 2 states that in order for a signature to be valid, each signer of nomination paper shall legibly print his or her name and shall list his or her municipality for voting purposes. 820 sub 5, nominations for offices of independent candidates provide that only one signature per person for the same office is valid. So when courts look at this issue of directory versus mandatory, what the Wisconsin Supreme Court instructs is for the courts to consider consequences that would follow when determining whether a statutory provision is mandatory or directory in character. And that's the Cross versus Soderbeck case from 1980. The consequences of treating section 815 sub 5 sub B as mandatory is that millions of voters will be deprived their right to select a candidate of their choosing for governor. The consequence of rightfully determining that section 815 sub 5 sub B is directory furthers the constitutional and statutory rights of Wisconsin voters. The next point that I want to make is that under the Election Commission's own administrative code, EL 2.05 sub 5, the nomination papers at issue are in substantial compliance with the statute, and therefore the commission may not reject them. 2.05 sub 4 provides any information which appears on a nomination paper is entitled to a presumption of validity. Going down to the next subsection, 2.05 sub 5 says that, quote, where any required item of information on a nomination paper is incomplete, the filing officer shall accept the information as complete if there has been substantial compliance with the law, close quote. That's the commission's own regulations. If we turn to commission guidance, which was promulgated and adopted in February of 2020, that makes clear this rule applies to information related to candidates. Those were exhibits C and D of my affidavit that Attorney Mandel referenced earlier. Now here, the nomination papers at issue provide two addresses that could be used to send mail to Mr. Michels. So those forms are substantially compliant. And the commission has previously taken this position that technical irregularities on a nomination form do not invalidate that form. The judicial candidates in 2018, William Cussell and Mark Furr, had their voting municipalities on their nomination forms, but their mailing addresses were technically in different municipalities than where they voted. The commission approved both candidates to the ballot. Further, the commission guidance indicates that the commission rejects challenges on the basis of a candidate's failure to include his or her municipality on a nomination paper. There is no one who has been defrauded or misled by the form of Mr. Michels' nomination paper. Where is the affidavit from someone who signed one of those nomination papers, said, oh, geez, if I had known that he actually has Heartland as a mailing address, I never would have signed the guy's nomination papers. These are substantially compliant. There's been no fraud in any of the signatories, and the commission should accept them as valid. Third point I want to make concerns the correcting affidavit that Mr. Michels filed on Monday, which removes any alleged deficiency, irregularity, and moots Ms. Bernstein's complaint. Going back to Administrative Code EL 2.05 sub 4, errors in information contained in a nomination paper committed by a circulator may be corrected by an affidavit of the candidate. Now, the purported error here was made by circulators because they inadvertently used the wrong form. And Mr. Michels, the candidate, has personal knowledge. He corrects this error by specifying that the address on the form that was intended for the circulator to use listed the city, state, and zip code as should have been Heartland, Wisconsin, 53209. His affidavit was timely filed and corrects any purported circulator error. Final point is this: Mr. Michels should be placed on the ballot because at this moment, he has timely filed a declaration of candidacy with the commission. He does not fall under any of the prohibitions set forth in Chapter 8, such as 830 sub 2, sub 2M, or sub 3. He is therefore a candidate. He's on file with the commission. The commission must then include him on the certified list of candidates under section 7.08 sub 2 and on the ballot under section 5.62. The commission may choose to exercise its discretion under section 830 sub 1A to refuse to place him on the ballot, but to do so requires the commission to take two separate actions, both of which must be done by a 2/3 vote. And this is required under Wisconsin statute section 5.05 sub 1E, 1E being one subsection. And this provision is cited in the staff recommendation memo requiring a 2/3 vote. First, the commission has to affirmatively find that the 3,516 signatures are invalid. All information on nomination papers is presumed valid under Administrative Code EL 2.05 sub 4. And unless the commission determines otherwise based on clear and convincing evidence by a 2/3 vote, the presumption remains and the signatures are valid. Second, if the commission finds that the signatures are invalid, then the commission may choose to exercise its discretionary authority under section 830 sub 1 to refuse to place Mr. Michels on the ballot. But once again, this exercise of authority requires a 2/3 vote under Wisconsin statute section 5.05 sub 1E. So if the commission fails to take either of these actions by a 2/3 vote, Mr. Michels remains a candidate on file with the commission, and the commission, all clerks, must include him on the ballot for August 9th. In summary, I would ask the commission to reject the complaint filed by Ms. Bernstein. Thank you.
Madam Chair.
Yes, Mr. Mandel.
Mr. Fernholz's last set of comments there about
Oh, wait a minute, are we going to allow rebuttal after rebuttal after rebuttal? I thought each was to have 20 minutes, that's it.
Well, that's what
I don't know what he's asking, Bob, and we'll decide whether he gets to talk about it once we have any idea what he's saying. I have no idea what he's saying right now.
Thank you, Madam Chair. My point was exactly that, which is that the last point Mr. Fernholz made about the idea that Mr. Michels must be placed on the ballot because of the presumption of validity and what would happen if there was a deadlock in this on this complaint is not addressed in their brief. And because of that, this was all new to me. I would ask a very brief moment to address that point because I had no idea that was going to be argued.
Can you do it in 90 seconds?
Yes.
Go.
Thank you. It is simply not true that the signatures are still afforded a presumption of validity. The commission staff memo says that we met our prima facie case. Even if the commission were to agree with the recommendation, the presumption wouldn't exist anymore. If the commission deadlocks, the presumption has really been displaced unless the commission votes that we did not make a prima facie case. If the law were, as Mr. Fernholz says, 2 years ago in the Hawkins case, the Supreme Court would have summarily reversed this court and ordered that Mr. Hawkins be placed on the ballot. Instead, the court did not do that. The court said that it was a merits question that had to be decided. There was not sufficient time, and it therefore dismissed the appeal. Mr. Fernholz's statement is clearly inconsistent with both this commission's precedent and Supreme Court law. Thank you.
I'd like to hear from Mr. Fernholz in terms of what he says about that. And I'm just wondering if the attorney supposed to give the commissioners their view on what the law is.
Well, I was actually going to ask Jim or Brandon, one or the other. I thought that was an odd position, and I wanted to know whether you agreed with that.
Yes, I would actually agree with Attorney Mandel's argument in that one respect.
Okay.
So can I just go through this because I'm a simple
Well,
person.
Mr. Fernholz, I think that's only fair since we're.
Okay, that's fine. I do want to ask staff about that, but go ahead.
Okay.
No problem
If you
with
feel
Mr.
strongly,
Fernholz.
we'll give Mr. Fernholz 90 seconds to.
Sure. Thank you. The statute 5.05 sub 1E is clear as to what decisions have to be made by the commission with a majority vote. And if it's anything other than procedural, it requires a 2/3 vote. Now, the commission deadlocked in the Hawkins case and made a recommendation that was contrary to the statute. And this was alluded to in the dissents in the Hawkins case. But a deadlock 3-3, particularly in this case where you have a staff recommendation to accept the signatures and allow Mr. Michels on the ballot. A deadlock 3-3 vote does not preclude Mr. Michels from being placed on the ballot. It requires 4, 5, or 6 votes for that to happen.
So my question, can I ask staff?
Go ahead, Don.
So right now we have a motion, the staff motions in front of us. And so we could do, I suppose, one of 3 things. I suppose we could adopt that staff motion, but with at least 4 votes. That's one option, right, Jim, or Brandon, or Megan, whoever wants to answer, right?
Correct.
And, or we could tie on that. It could be a draw, right? Or we could have, there could be a motion that would be the opposite, that could prevail, right? So what happens if there's a tie?
This is the question we have addressed in many contexts. And frankly, I think there isn't a lot of clarity here, but any action other than procedural requires a 2/3 majority. And so I think the court appeal that would subsequently, happen if that deadlock were to happen is the option. And as stated, I think that's kind of why the Green Party case landed in court to begin with.
So I just, again, I want to play this out. So prior to the complaint being filed, Mr. Michels was on the ballot, right?
No.
And the staff recommendation would not, I think it may have been alluded to that the staff recommendation would get that person on the ballot, and I don't believe that to be true.
Okay, well, so let me understand. So you're telling me that if Jane Bernstein had not filed the complaint, Mr. Michels would not be on the ballot?
Not without the commission's vote on ballot access that happens subsequent to the numbers we tally here.
Fair enough. So, but that's true of every candidate, right? That's true of Peter Gilbert in Senate District 7, right? I mean, I'm just pulling a name out, right? Okay. So okay, leaving that aside. Okay, I understand that part. Okay, so if for some reason either it's a 3-3 vote on, well, okay.
Hold on, Commissioner Thompson may have some clarity for you. Mr.
Okay, fair enough.
Would you like to let him pipe in?
Sure.
At the bit here.
Let me
just point out.
my
Hold on,
thought.
Bob. I recognized Mark.
Let me just give you my thoughts on where we're really at. And there's been a lot of discussion about the Hawkins case. September 14th, 2020. I've read this decision many, many times. If there was a decision addressing the Wisconsin Elections Commission that there was a sense from all justices that the vote we took on that election wasn't right, it's there. You don't have to read the dissent. So the starting point is, I think, to me, and I just wanted to throw some things out here. Mr. Mendel threw out this issue that Mr. Michels maybe lived out of state.
Mark, I didn't recognize you for that. I thought you were addressing Don's questions about what happens when we vote. You're not answering.
I am, because I think his.
Hello, I'm going to allow Don to finish then. I thought you were writing answer.
Never mind. I'll wait till later.
My questions are really mechanical. I'm just trying to figure out the process. That's what I'm trying to do. So
I don't think you're going to get 3-3. So
let me just mention and straighten up on the Green Party. One of the reasons why the Green Party didn't get.
You are not recognized. I'm letting Don finish his comment because he had questions. I thought he was getting an answer. He wasn't. Don, you're allowed.
So here's my question. So let's assume that it's a 3-3 tie on this question in front of us. Okay. Mm-hmm. Later on, we're gonna vote on the list of candidates, right? To go on. So what's the procedure there? Just so I'm clear, so if it's a 3-3 tie, or the commission rejects the complaint.
Yep.
And I'm assuming in both of those cases, Mr. Michels' name is along with all the other ones. And in the procedure would be typically up or down on the roster. Is that the way it's worked typically?
I think.
I can address that.
What's their challenge?
No,
Okay, right, okay.
In the Hawkins case, the recommendation was that they wouldn't be put on the ballot. It tied 3-3. That recommendation was what took place. They weren't on the ballot. That's how it occurred.
Okay, because it
Yeah, and
was significant for him to get on the ballot.
And that goes through the whole delegation of authority issues, et cetera, et cetera.
All I'm trying to figure out.
Right now, Don, is if it's 3-3, the recommendation of the commission would say that there are valid signatures to put Mr. Michels on the ballot. Then we would have a separate vote on whether they would.
Right, okay, so my question is, again, procedural. I'm not really, you're probably reading more into it. I just want to know what happened. So let's say that for whatever reason, the complaint doesn't prevail, either 3-3 or only 2 votes for it. Fair enough? So we're gonna have a vote, and Mr. Michels ostensibly would be in the same position as Peter Gilbert, the Republican candidate in the 7th district, and all the other ones, right? At that point, someone could move to object to Peter Gilbert or Mr. Michels. Am I getting that right, Jim? You're nodding, right?
Yes, absolutely. If you had, independently reviewed materials and felt there was some kind of discrepancy that needed to be talked about, that opportunity would be given. You can ask questions of staff.
Right.
I think the main difficulty, and I agree with Commissioner Thompson, is, ultimately we would deadlock. And if the commission had no additional motions or, opted to move on, that item would still be on the agenda, but we wouldn't have a tally on a pending challenge, if you will. And so I think where this gets difficult is, the commission might still choose to vote, and they might affirmatively vote what the unchallenged staff recommendation is. I just think that potentially opens you up to an appeal in a new way. And that's where these 3-3s get so difficult. And we've tried to look into it, and we've tried to seek advice, outside of the agency, and we never really get or find anything. And I think that's why you just have to almost anticipate a court appeal on those decisions, because it just doesn't result in any action. And sometimes we've even seen this in the context of a mandatory statute. And the questions kind of come up, what happens if the commission deadlocks? Well, I think the only answer is you end up in court.
And then the last scenario is, let's say that the staff recommendation is reversed and there's 4 votes to accept the complaint, and determine that Mr. Michels didn't have enough signatures.
Mm-hmm.
Then I keep thinking this afternoon, well, it's already this afternoon. So then later on this afternoon, we're going to have a vote. Then would Mr. Michels be part of the roster, or would it take an affirmative vote to put him on the ballot again?
He would be part of the not recommended group.
Not recommended.
Yep. So if the challenge were sustained, yep, it would fall into that category. If we adjusted, the staff will be, let's say we did sustain it, and he was moved forward, the staff are adjusting these numbers as you're deciding this. Part of the lunch break was adjusting those numbers for everything that they decided.
So you need 4 votes to put him on the ballot?
Yes.
Okay. That's really all I was trying to get at. Okay, thanks.
Okay, so that was the procedural part of that.
Right. Yep.
Okay, Commissioner Scannell, I know you want to be heard. Go ahead.
Let's just go back to the Green Party for a second. If you remember, the commission determined the number of valid signatures, which was less than the number that was needed to get on the ballot. So right off the bat, that was the basis for one of the bases for not putting the Green Party on the ballot. And then, of course, there was a 3-3 vote about putting them on the ballot, which they did not. And of course, there was a 4-3 decision, as you may remember, with the three minorities saying that such an action was a criminal act of the Wisconsin Election Commission because we did not put him on the ballot. So there's several different things involved in this. I think what was stated behind is saying, are we going to say that his 3,000 and some odd ballots or signatures are not legitimate? And then if that brings them below the margin that's required to be that you need to get on the ballot, then that's sort of like what happened with the Green Party.
Can I ask, well, I also meant to ask a question of Attorney Fernholz, since they're still up there and not been shuffled off. Is that okay?
Absolutely. My view is like, this is our opportunity to learn the information we need to know.
So my question is, there was a reference to a voicemail. Attorney Mandel had made this reference to a voicemail and all that. I guess my question is related to that. Did the Michels Commission, I'm sorry, Michels committee ever submit nomination papers for review by the commission, which many candidates do?
We did not. I don't believe so, Commissioner. And in terms of the voicemail, it's the first I've learned of it. I don't know anything about it. It's not in the record, so I don't know what value it has.
Okay, that's all I had. Thanks.
I did want to ask about that. Thank you for asking that. There's Mr. Mandel. What was the voicemail and what did it say? That help me out there.
Sure. First of all, I just want to say we filed an open records request for all communications between the Michels campaign and the commission related to nomination papers. We did not get anything that suggested the Michels campaign had submitted in advance and asked approval. Secondly, the voicemail was a May 26th message left for Riley Vetterkind by a woman by the name of Mary McNulty, claiming to be calling on behalf of the Michels campaign with some questions about nomination papers. That is all that the voicemail said. It is all that I know. I assume that Mr. Witeka could play the voicemail for the commission if you would like. And I imagine if Mr. Vetterkind is around, he might be able to answer whether he returned that message or anything like that. The only records we received in response to our open records request were a copy of that voicemail and copies of materials related to this complaint. So to my knowledge, that is the only, those are the only records that related all in the commission files to the Michels nomination papers.
All right, well, that answers that.
I have a question for Mr. Mandel.
Sure.
I was listening to your talking to us about that. Are you saying that if I were to live in Chautauqua, Wisconsin, and somebody addressed a letter to me at my address there using Chautauqua, Wisconsin, or whatever, that it would not get to me?
My point, Commissioner, is that if it said your street address and in the village of Shaniqua and said nothing more, it would not get to you. The Postal Service Domestic Mail Manual is exceptionally clear that all mail must have a municipality and a state. This did not.
Okay, so if I had my address, say, at Main Street or whatever in Chautauqua, 1234 Main Street, Chautauqua, that probably would not be delivered to me. Is that right?
That is my understanding, and that is first with the
let me ask you this question. Do you know what the address is for the Village Hall of Chautauqua? That's where people send their taxes, where they send their information and everything like that. Could you tell me what the address is, or at least what the city may be for that's on the website? I'll give it to you. It's 313275 West County Road, Chautauqua, Wisconsin. And it has a zip code of the same as 53029, the same as Heartland. So it appears to me that anybody that sends a letter to somebody in Chautauqua, Wisconsin, because they don't have Heartland, Wisconsin on it, is going to get to them anyway. Sort of almost like in the Milwaukee County. Just about we have 16 or 17 different municipalities in Milwaukee County. In every one, you could put Milwaukee, Wisconsin there with a zip code. So I think that the argument that people do not receive mail, if this is what you're saying, with a Chinako, Wisconsin address of the city of Chinako rather than Hartford, it just is not the case.
Respectfully, Commissioner Spindell, that's not what we're saying in the least. And I agree with you about exactly what the address is. It's Exhibit 6 to the Miller affidavit. The problem is it's unhelpful because it is addressed to the village of Shaniqua, 31275 West County Road K, Shaniqua, Wisconsin 53029. Neither Wisconsin nor a zip code appears with Mr. Michels' mailing address on the vast majority of the nomination papers. That's what makes it not an effective or sufficient mailing address. We do not disagree. I am not saying that mail will not get there if you write Shaniqua, Wisconsin instead of Heartland, Wisconsin. What I am saying is that in the 21st century, writing a street address and in the village of Shaniqua with nothing else is not a sufficient mailing address. That is true under Postal Service guidance. It is true under what we were told by the post office, and it is true under just a common sense reading of the statute and what a mailing address is. We all know this.
We're not required, never required on any of these documents to have a zip code, for example, on the petitions that you're talking about, on the circulators, address and so forth. We require a municipality there. We do not require a zip code. And the presumption there that the person is, they don't even have to put Wisconsin.
I agree with that, Commissioner Spindell, but there's a big difference. First of all, and you are correct. In fact, in the header of the nomination form, according to the Elections Commission guidance, there's no zip code that's required there either. But there is a state required. The form makes it quite clear, and it's missing here. The other difference I would say to you is that to be a signatory on one of these nomination papers requires being an elector in the state of Wisconsin. So yes, the commission presumes that people, if they leave the WI off of their address as a signatory, that they are perfectly valid because they are signing that they are electors. But Mr. Michels as a candidate is not doing that. He is required under 8.15, subdivision 5, paragraph B, to put his mailing address on each of his campaign's nomination papers. He did not do so.
Well, to be a circulator in Wisconsin, maybe correct me if I'm wrong, I do not think that you have to be a citizen of Wisconsin. Am I correct? If you look at Kanye West's petitions that were just fine, they were done by a lot of people from out of state.
I agree with that, again, Commissioner Spindell, but again, that's not what I said. I didn't see to be a circulator, you had to be an elector in Wisconsin. I said to be a signatory, to sign the nomination papers, to be counted as a signature, you are signing that you are an elector of the state of Wisconsin. So the commission presumes the WI in those addresses, but you are correct. You don't have to be an elector to be a circulator, and that is a different requirement than the section 8.15 subdivision 5 paragraph B requirement that each candidate shall include his or her mailing address on each of the candidates' nomination papers.
Okay, so you're saying everything is fine with his mailing address now, except he didn't put the state in. Is that a correct statement?
What I'm saying is that it is
in there, that's okay. But the problem here now is that he forgot to put the state in, or he didn't put the state in.
Well,
so really the problem, the objection that you have with his address right now is that he did not put in the state.
Well, I think it's slightly more complicated than that, Commissioner Spindell, respectfully. What I would say is this. He is required to put in a mailing address. This commission's materials are very clear that a mailing address is, if you have a different municipality than you do for voting purposes, you're required to put that in. He did not do that. What I would say is that that would probably qualify for substantial compliance if he'd specified the state. But he has not put in a valid mailing address, nor has he achieved substantial compliance because something mailed to a street address in the village of Shaniqua, full stop, will not be delivered by the United States Postal Service.
Okay, and so anybody sending anything to the village hall of the village of Shaniqua, a village that has a president, that has a town council, that has a clerk, and this, I think this applies to the next case we're going to also. where it's the same exact situation, in my opinion. If somebody addresses a letter to the place that she lives, that's going to get there as well. So, I mean, what we're talking about now is we're talking about both items. And so are you, maybe just to maybe explain one more time, you're saying that if a letter is addressed to the Village Hall in the village of Minocqua, and they do 31275 West County Road, Chinauqua, Wisconsin, and won't get there. It's gonna, because Heartland isn't in there.
Well, again,
And I think what you're missing, I think what you're saying, because I think you agree with me that mail will be delivered to somebody in Chinauqua. I think what you're saying now is he doesn't have the state in there.
again, Commissioner Spindell, I want to be clear. He has not complied with the statute because he doesn't have Heartland, Wisconsin. It would be substantial compliance. That's a different issue if it said Shaniqua, Wisconsin, because I agree with you that properly addressed mail that uses Shaniqua as a mailing address does get delivered to proper addresses in Shaniqua. There is no proper address. I'd also like to go back to your question for a moment about the missing WI for signatories, because if you look at Wisconsin statute 8.15 subdivision 2, which is the statute that governs signatories, they are not required to put in a mailing address. They are required to put in a street name, a number, and a municipality for voting purposes. So they don't need to write WI. The statutes expressly don't expect them to write WI. That is different than 815 subdivision 5 paragraph B, which says mailing address, which we all understand includes the locality. You're in Greece, Commissioner, I believe I heard you say earlier. If I sent something to 1234 Mykonos Street, Athens, would you expect it to get there if I didn't write Greece on it? I don't think you would, because there are lots of places in the world that use the municipality named Athens. Now, Mr. Fernholz says
the state, your state isn't there, but you're saying that if he had Chinauqua, Wisconsin in there, we wouldn't be having this discussion. Is that right?
According to the Postal Service's domestic mail manual, that would be deliverable. But what they did is not deliverable. It is therefore not a mailing address. It just isn't.
Yeah, okay, well, I don't think we need to continue, but I think it's pretty clear that if somebody uses the city of Chinauqua, that the mail's gonna be delivered to them, even with the same zip code as Heartland, and you do not have to write Heartland in there to have a piece of mail delivered there. So
Commissioner, the last thing I'd like to say in response to our colloquy here is that my example of Athens, of course, is a municipality that appears in multiple states and obviously in the country of Greece and possibly in other countries. The Michels campaign asserts that the village of Shaniqua is the only such place in the world, but they cite to the Miller affidavit, which says no such thing. So they don't have any evidence of that. The only thing that they could potentially point to as evidence is one of the Miller affidavit exhibits that is a Google search for the village of Shaniqua. But what I would point out is that there are 151,000, I'm on page 1918 of the commission materials. That search generated, quote, about 151,000 results, end quote, and they provided this commission a printout of the first 3. And yes, the first one on their printout is the village of Shaniqua, Wisconsin. But Google knows a whole bunch about your search history. And so if I search for Athens restaurant or Athens Euros, it's going to give me the one closest to Madison, even if I don't say Madison, Wisconsin, because Google knows that I am generally in Madison, Wisconsin. So the fact that the village of Shaniqua, Wisconsin was the first of these 151,000 search results in no way, shape, or form is actually demonstrative that there is no other municipality in the United States or in the world named Shaniqua. We don't know that. It's not in the record. The commission staff says that.
Don't need any of this, but if you sent me a letter now and you addressed it to Athens and you put Greece, it'll probably get to me. You don't have to put the local state here.
Well,
But,
that's because Greece doesn't have the same kind of federal system we do in the
They don't
country,
have-
probably the size of one of our smaller states. But the postal manual says you must have a
All I'm just pointing
municipality
out
and a
is
state.
if you get a piece of mail, and I don't think we need to continue with this, but if a letter is addressed to me if a letter is addressed to the village hall in Chiniquah, and they use Chiniquah rather than Heartland, it's going to get there. That's all I'm saying.
If it has a state or a zip code, but not if it simply says in the village of Shaniqua. The
Okay,
postal
then
service says that's
what he
insufficient.
missed was Wisconsin, right?
I'm sorry?
Yeah, that's all I'm saying.
Okay. I had a question for Mr. Fernholz. You turned to Merriam-Webster's dictionary for the definition of a mailing address. Mr. Mandel directed us to the US Post Office, which gives us the specific elements of an address. And does require a state. Shouldn't we take the word of the post office over the dictionary?
You can do both. It complies with the dictionary definition, which is the standard Wisconsin Supreme Court methodology for interpreting undefined terms in statutes or regulations. But if we then just limit ourselves to the post office, you can find that the zip code lookup tool returns the same address and zip code for both 6831 State Road 83 Village of Shaniqua and 6831 State Road 83 Heartland. So regardless of whether the mail is sent to the Heartland address, the Shaniqua address, the United States Postal Service confirms that it's going to get there. And that point seems to be conceded. It's just that Attorney Mandel's argument now is, well, if you would just put comma WI after it, that would comply and Mr. Michels could be on the ballot. But there, as we pointed out, they have not demonstrated where else the mail would go to, what other Shaniqua there is in the United States of America. We're getting into the weeds on this. I mean, the idea that Mr. Michels' mailing address would be someplace other than the state of Wisconsin is a creative argument, but it is not credible. He's clearly running for governor of the state of Wisconsin. He's filed registration papers to run for governor of the state of Wisconsin. So yes, the presumption is that the mail is going to be addressed to Wisconsin, and the return address on the nomination papers lists a PO box, of course, in the state of Wisconsin.
So that didn't really answer my question. What you just pointed me to is a zip code lookup tool. But what I was asking was, the post office defines a mailing address as including a state. And is there somewhere in your materials that you can point me where you've got someone saying that if I don't have a state or a zip code, that the mail is going to be delivered as opposed to returned to me saying no such address? I mean, because that's what happens, right? It's not that it goes somewhere else necessarily. It's that it comes back to me and it says, you didn't give us enough information to deliver it.
We have Mr. Michels' affidavit acknowledging that if it's addressed to 6831 State Road, Shaniqua, he's received mail that has that on there.
And I want to be clear. He's swearing under oath that if it doesn't have a state and doesn't have a zip code, that he has a specific recollection of having received mail of that type.
I think his affidavit, as he recalls it, being addressed to Shaniqua. I don't know if he can verify that there was a missing WI on it as well, but
I mean, because that's really the question, right? Like, it sounds plausible that if it had Wisconsin and a zip code, it would get to him. And I think that appears to be agreed on. What I'm trying to figure out is, without that additional information, that would be an odd thing to have a specific recollection of. And it seems to me that that's at the heart of this, that it's missing an essential element of a statutorily, or not statutorily, defined by the post office, who is in the business of defining these things, says you have to have a state or a zip code, and he's got neither. So that's what I'm trying to wrap my head around here.
sure. And then we go to the alternative analysis, which is that there has been substantial compliance. because the commission's own administrative regulations say substantial compliance is sufficient. So he's given the street name, the number, the municipality, and he is a declared candidate in the state of Wisconsin. That is sufficient compliance. It's noted in the staff recommendation memorandum, and it's consistent with the commission's prior precedent. So if the commission is going to take the position that it doesn't meet the precise definition of mailing address, even though that's not defined in the statutes, then we go to substantial compliance, which is what the commission has told us it is looking for because it's in the commission's own regulations.
Madam Chair, can we sort of end the discussions with the lawyers and proceed on what the motion is going to look like, and then a discussion between ourselves about what we're going to do?
Sure. Mr. Mandel had his hand up. I'll let him sort of answer whatever Mr. Fernholz just said, and then we can excuse them and converse amongst ourselves. I think that's fine, unless anyone objects to that. Okay. Mr. Mandel, go ahead.
Thank you, Madam Chair. Three quick things in response to what Mr. Fernholz said. First, it is not true that under Wisconsin law, we start with the dictionary. We start with the common sense meaning. It is only if that doesn't get us somewhere that we look to outside materials. And we would only look to a dictionary for a common term. Here, if the commission thinks that mailing address is a specialized term of art, then it should look to the proper source, which, as you suggest, is the Postal Service. Second of all, it simply isn't the same to say that the precedent is the same or that there's been substantial compliance when those prior cases included the state. A mailing address under the Postal Service has the following elements. It has to have a street number, a proper street name, a municipality, and a state. We are willing to concede, as I was explaining in my back and forth with Commissioner Spindell, that if the municipality is the voting municipality rather than the mailing municipality, that will generally be substantial compliance. But that is different than saying that if an essential element is missing, that it is substantial compliance. It is not substantial compliance to give a partial, incomplete, undeliverable address. Last but not least, I want to point out that the argument that Mr. Michels is pressing upon this commission, and that I really urge the commission to reject, is that a candidate for office should be held to a lower standard than an absentee voter is held to with regard not even to their own conduct, but to the witness's conduct. That really seems inappropriate. And lastly, Mr. Fernholz wants there to be an inference that the candidate doesn't need to write Wisconsin because it's implied. But these same nomination papers are used for people who are running to get on the ballot for the presidential preference primary, most of whom don't live in Wisconsin. If they left off their state, what would we do? How would we know? It simply isn't appropriate to be implied, especially because Mr. Fernholz can continue to diminish this argument. But in the dead center of the nomination circulation period, on May 5th, 2022, and this is just one example, we found many, many articles. The Wisconsin State Journal ran an article called "Gubernatorial Candidate Tim Michels Responds to Out-of-State Residency Questions." 20 days into a 45-day period. There was substantial discussion, and I think there still might be in debate about what state it is that Mr. Michels lives in. And he did not write WI in his address. It is not a mailing address. Thank you.
Okay. With that, I guess we will excuse Mr. Mandel and Mr. Fernholz to the attendee room. And at Commissioner Thompson's suggestion, we can talk amongst ourselves about this. Go ahead, Commissioner Thompson.
As I was trying to say earlier, I think the Wisconsin Supreme Court sent this commission a message in the Hawkins Walker versus WEC case. And I think it was pretty loud and clear that the purpose of the statute and when you're evaluating nominating papers is to let the people vote after the people get on the ballot. in my mind, listening to Mr. Mandel, and I'll be blunt out there, I agree with him most of the time. But his arguments on viewing this mailing address sounded to me very much like the sheriff in Racine County that wanted to put 4 of us in jail because we took a view that shall was directory and not mandatory. I agree with Mr. Michels' lawyer on this. This is directory. This is not, this use of shall is not mandatory. It defies to me, common sense that anybody looking at these papers would think that Mr. Michels wasn't living in this state and running for governor. And I think it is directory. When Mr. Mandel talked about Zignegno and that kind of strict reading, I mean, there were 3 of us were found in contempt by the judge, and ultimately we were right on the law, right? It didn't read like that. The bigger question is, are there signatures, valid signatures from Wisconsin supporting a candidate for governor? And should that person go on the ballot? Common sense and justice to me say, of course. There's no reason to keep them off. I think people would get very, very upset. I think we would get reversed immediately. And it just wouldn't be fundamentally fair. I have big problems with Judge Bourne and his review of our position on drop boxes and our use of discretion. But he read it very strictly. We're going to find out whether the Supreme Court agrees with this. But I think to take this kind of approach, mandatory nitpicking, on this question, it's just wrong. In my mind, there's no doubt that the valid signatures and the staff position ultimately is the right one. Now, I don't know whether it was presumptively, the papers failed, and that there is no question in my mind. I don't know whether we have to decide that they are in substantial compliance, and that, nobody, if Mr. Michels actually lived out of state, this record would be full of tons of evidence that the Chautauqua wasn't Wisconsin. And in my mind, there is just no question. Now, I think candidates running against Mr. Michels may have disagreed with some of the things Mr. Finalize said, that he was the front runner. I mean, I don't know if he's necessarily front runner. But I do have to say one thing that I really appreciated about Mr. Michels' filings, and that was footnote number 7 of their brief. And I think this is really, really important, because Mr. Michels, who is backed by former President Trump as the candidate for governor, rely on the WEC canvas as the factual basis for the assertion of the number of people votes. And when I looked it up, footnote number 7, I printed it out. And the first thing I noted was that the winner in 2020 was President Biden and the loser was Trump. So I appreciate that in this process, there's a recognition that the 2020 election was legit. There was no fraud. And I think we would make a big, big mistake if we kept Mr. Michels off this ballot.
So philosophically, I agree with Commissioner Thompson that we need to be thoughtful and careful when keeping people off the ballot while still allowing people to make their full arguments, which I think goes back to why I would have accepted the brief, even if I'm now going to probably vote against it. It's important that we consider these challenges and consider them thoughtfully. It's why I asked us to look at each of the 4 signatures that were illegible earlier today, and we were able to come to consensus on those. Because keeping someone off the ballot is a serious matter, and generally speaking, the voters should largely decide. I do think that Mr. Mandel's point, which is that we have to recognize substantial compliance by voters, by signatories, by, you know, in all those different circumstances. And it's very easy to be dismissive of that idea. And I think we have to keep that in mind as we go forward in this situation. I see the basis for the challenge. I think it's appropriate to make it. I don't think it was frivolous, but I also don't think it rose to the level where we can argue that it's sufficient to keep someone off the ballot, is my inclination on this. It's up to the voters. Commissioner Spindell.
I'd like to go ahead and make a motion that we approve Tim Michels for ballot access.
Well, you skipped a step. You can't
Let me
do
say
that.
that we follow the recommendation of the staff.
All right, that's closer. Okay, let me take a look. I gotta find it. It's page 1454, so I can read what it is.
I think based on the discussion the commission just had, you may want to craft the motion somewhat differently based on the reasoning. So the staff memo had initially that the burden was met. Based on the commission's discussion right now, I'm not sure that you agree with that. I'm not sure if you want to readjust what the motion says or not, if it was based on the reasoning for
I don't agree with the motion as drafted, but I'm looking at page PDF 1458. And I don't know why our motion in this would be any different than the motions we made in the other one. Because I'm not sure that we have evidence that it'll result in consistent mail delivery to the appropriate locations. And I don't want to direct staff to include that because I think this is really spec specific. And I think the motion is properly that the challenge, that the commission does not sustain the challenge to Timothy Michels' ballot access as set forth in EL 22-46 Bernstein versus Michels. Isn't that basically the same words we used for the other ones?
Yep, that sounds good. Just the additional sentence there might have.
Bob, are you okay with the motion being exactly the same as all the other ones that we
I
did?
voted exactly the same as it was. in the
Okay.
initial.
So the motion, as Bob just approved it, is that the commission does not sustain the challenge to Timothy Michels' ballot access as set forth in Bernstein v. Michels EL 22-46. That is the motion. Is there a second for that motion?
I can second.
Commissioner Bostelman seconds that motion. And can you confirm for me, Jim, the number of valid signatures that would then be assigned to Mr. Michels? 35, it looks like 3861. $38.61, yes. I'm looking at the,
Yes.
Yep.
okay. All right, we have a motion, we have a second discussion. Commissioner Thompson.
Yeah, I mean, just briefly, I said, what I said in terms of generally, so I'm going to support the motion. I do, however, hope that candidate Michels thinks through what he says on TV and his ads when he points to, and he's had a lot of discussion about us as a commission. And I think he said things publicly that's just not true about us, and said comments that are in a disparaging remark. And I think he should take note that, I mean, what Mr. Mandel pointed out to the world is that sometimes the law, it can be stickly. Different people can construe it differently. And his point, he's out there always yelling, saying that, you know, you've got to follow the letter of the law. If we would have done that, he might not be on the ballot. Now, he's not on there yet. But I would just hope that Mr. Michels, and frankly, all the other candidates running, really stay true to facts. And I'm just reminded and thank Mr. Michels again for footnote number 7 and his confirmation that our canvass was correct for the 2022 vote.
Is there further discussion on the motion?
I have a point of personal privilege. I was texted, I'm going to say this because we probably have more people watching now. And someone texted me saying, you look like you're looking off into space. I've got this really cool monitor up on the wall up here. So when I'm looking like that, I'm actually looking at various documents. So I want you to know I was paying attention to everything you guys said. I was not staring off into space.
Well, you know, I'm sure you find these meetings as scintillating as we all do.
Oh, I've got us on there, so I'm in. I got 3 monitors here with all of us.
All right, well, you're set up.
Yeah, that's right.
All right, is there further discussion on this motion? Hearing none, I'll call the vote. Commissioner Bostelman,
Aye.
Commissioner Clancy,
Aye.
Commissioner Millis,
Aye.
Commissioner Spindell,
Aye.
Commissioner Thompson,
Aye.
carries 6-0. Chair votes aye. Motion carries 6-0. Mr. Michels will have 3,861 signatures. Next, we have Ford versus Schechter, which I am hoping we can do since we just went through the same sort of issue promptly. It is EL 22-47. Could we please bring in the representatives for Ford and for Schechter? And then meanwhile, it looks like it is Mr. Hunsicker. I don't know why you two split this up if it's basically the same issue, but have at it, whoever's presenting.
Yeah, so I think I'll try to do a shortened version based on the discussion that we just had.